Hello, I'm Paul Schrantz, Director of Business Development and Client Success for Vendor-Centric, your one source for vendor and third-party risk management solutions. Welcome to our Expert Insights interview. This is a series of interviews where we take a few minutes to talk with our leading experts to share their insights about important topics of interest. In today's discussion, I'm fortunate to talk with my colleague, Jeff Tenenbaum, Managing Partner of Tenenbaum Law Group, PLLC, a three-lawyer boutique law firm in Washington, D.C. Jeff is widely recognized as one of the nation's most accomplished nonprofit legal professionals, a top leader in the nonprofit bar, and a distinguished thought leader and active participant in the nonprofit legal community. In our discussion today, we'll be hearing about Jeff's perspective on the importance of mitigating risk with vendors and other third parties using effective contracting standards. Welcome, Jeff. It's great to see you today. Thanks for joining me and sharing your perspective about the importance of contracting standards to mitigate risk with vendors and other third parties. Before we get started, can you introduce yourself and talk a little bit about the Tenenbaum Law Group?
Sure. Thanks, Paul. Thanks for having me here today. As you know, Vendor-Centric and I have had a long-time relationship. We've done a lot of things collaboratively together. I've done a lot of speaking with Tom Rogers. I've known you for many years and think very highly of the company and the work that you do. In terms of my firm, I started Tenenbaum Law Group a little over a year and a half ago, January 1st of 2020, as a boutique based in Washington, D.C., a law firm focused exclusively on the representation of trade and professional associations, charities, foundations, international NGOs, and other nonprofits. I started the firm with Nisha Tucker, my colleague, along with our assistant. We've since added a third lawyer, Julie, to our team. So we're a three-lawyer boutique. We primarily serve as outside general counsel to most of our clients. Whether they have in-house lawyers or not, we deal with a very, very broad array of legal issues that face nonprofits, including, of course, in the area that you guys do a lot of work in with contracts, but really everything else from federal tax exemption and tax exempt status to employment issues, copyright, trademark, regulation of lobbying, political activity, mergers, joint ventures, internal investigations, external investigations, and kind of everything in between. So it's a very kind of broad, diverse practice. We represent about 400 organizations right now, primarily national nonprofits. Probably about 2/3 are trade and professional associations in just about every industry and profession imaginable, and then a wide variety of other types of primarily 501c3 nonprofits, charities, foundations, international NGOs, arts and cultural institutions, think tanks, and the like. So yeah, the firm is, as you know, I spent most of my 25-year legal career at a large law firm called Venable and chaired the nonprofit practice for most of that time. But I've always wanted to have my own firm and be able to do things in the way that I think really works well for the nonprofit community. And it's really, really resonated well. It's been extremely gratifying. We've been already received quite a number of kind of honors and awards, even in the short 1.5-year history of the firm. We've gotten tremendous feedback from our clients, and frankly, I've never had this much fun practicing law. So, considering that all this happened during a global pandemic, I definitely knock on wood and count my blessings every day.
That's wonderful. I'm glad to hear about the continued success, and it's exciting to see what comes ahead of you. One of the things I'd be curious to get your insights on can you talk a little bit about the importance of contracting standards with risk mitigation? Because again, as you said about the pandemic, so much has occurred over the last 18 months or so. Obviously, contracts have been a essential part of how people have had to deal with respond to the negative impacts of this pandemic. So I'm just curious what your thoughts are on those contracting standards and how you use those with clients to mitigate risk.
So I cannot stress enough the importance of contracts. It is a bread and butter part of our practice. It's always been a bread and butter part of my legal practice, and it's no different in our firm. Julie and Nisha and I spend time every single day reviewing, drafting, negotiating contracts of every type. Every contract is a little bit different in terms of what are the most important provisions in that contract, and it really varies from one deal, one venture, one contract to the next. But having dealt with, especially over the last year and a half and continuing on to this day, dealing with so many contracts for meetings and events, which have just, particularly in the association community, have completely, the pandemic has completely upended in-person meetings and events. We've worked on probably close to 700 different meetings and conferences right now and looked at all of the underlying contracts for those and helped our clients with strategies to try to negotiate their way out of those contracts without paying cancellation penalties. Now trying to renegotiate contracts to be able to hold in-person meetings but not get hit with significant attrition penalties because you're not going to have the same sort of attendance. It's actually come, unfortunately, because of the resurgence of the pandemic recently. It's kind of come full circle. And, almost every day from when the pandemic started through the end of last year, I had calls every day with clients about how to get out of their contracts, how to cancel them, how to negotiate to kind of push the meeting back a year or two and try to mitigate cancellation penalties. Then, as vaccines started to come online this year and everyone got a lot more optimistic and started planning for in-person meetings, then we started to spend so much time on, how do you hold in-person meetings in a way that protects the health and safety of your attendees and your staff, and how do you mitigate your liability risks, and should you require liability waivers? Can you mandate vaccinations or negative COVID tests? All of that. Now, unfortunately, every day I'm having conversations like we had last year. We were planning our in-person meeting. This is one from yesterday for November in San Antonio, Texas. We're hearing from so many of our members that they're just not comfortable attending, and so we want to cancel. What can we do? And so you always have to, first off, it's a lot more difficult dealing with that issue this year than it was last year, because these provisions in a contract called force majeure, which if the force majeure provision applies and say some unforeseen event like the pandemic makes it illegal or impossible or commercially impracticable sometimes to perform another contract, you can get out without penalties. That we were able to utilize that very successfully at a time when states and cities and counties had all sorts of restrictions in place that banned large meetings and large gatherings. Now that virtually all of those restrictions have been lifted, the force majeure clauses really don't work anymore to give you leverage. So you have to try to gin up additional leverage, and it becomes even more difficult in places where there is just a culture of, we are open for business. No, we're not going to let you out of your contract. We're not going to let you cancel. But coming back to the contracts, the language on the contract itself, I have another call in a couple hours this afternoon with a client that wants to try to get out of their contract. And we go first to the various contract provisions. And there's so many things that you can do. Just 2 days ago, the session that Nisha and I did for the ASAE, American Society of Association Executives annual conference, it aired, and it was all about meeting contracts. And we did a deep dive into various contract provisions and how you can write, these provisions in a way going forward for your future contracts to try to give you more leverage, more of an advantage in when issues come up with hotels and convention centers and other meeting venues. But bottom line, contracts are critical. Everything from the kind of provisions I was talking about in meeting contracts, to termination, scope of work, payment issues, obligations of each party, getting into the more kind of legal, what some people view as legal boilerplate, things like indemnification and limitation of liability. Intellectual property provisions are critical. If you're going to pay someone to create some work product for you, you want to make sure that you get the work product assigned over to you, or that's deemed to be the work made for hire, so you own the copyright in that work. If it's a contract where you're going to we're working on one this week where it's essentially a certification program, and the organization is going to allow certificates to use the logo of the organization. You have to, create a trademark license to put strict limits on the use of that logo. I could go on and on. I've given entire webinars on contracts, but you don't have to tell me the importance of a good contract. And when we come in after the fact, we got a dispute with a vendor and they're trying to get out of the contract, but the contract really doesn't have good, it doesn't have like a termination without cause type provision, or it has a non-compete provision. We deal with this issue a lot. That makes it really difficult for, the association to terminate the contract and then still continue in that line of business if it has a non-compete provision. We unfortunately had a client that got sued fairly recently for copyright infringement, an association. And that we're actually very optimistic about the suit insurance carrier brought in a litigation counsel, but we're still advising on the case. And we're optimistic about the outcome, in part because the contract provision did not have an actual non-compete provision. It had a provision about the intellectual property that was created by the vendor that my client hired, but it didn't. It could have had a broader non-compete provision, which would have made the situation much more difficult for my client. That's not the case, fortunately. And so the contract language matters, is what I'm trying to say.
Yeah, absolutely, absolutely. Well, that's great. Those are great insights. I appreciate that. And you kind of touched on it, but just any additional, as you reflect on the last year plus and all the dramatic impacts that have occurred. Anything specifically that you've worked on with clients? I know the meeting events are a big area with impacting vendors and the third parties, because I've heard even at a personal level. I have a close colleague who had a planned wedding, and the wedding had to be postponed, and there was a cancellation clause in the contract that cost him a lot of money, and he was not able to negotiate out of that clause in that contract. So to your point about contracting standards, making sure both on your side as well as the vendor or third party you're working with, that you're addressing things to put yourself in the strongest position possible. So any additional things that you've kind of addressed and worked on, any data privacy, cybersecurity issues that you've been impacted with, or clients over the last year plus in regards to working with vendors and third parties?
Yeah, I mean, there's so many issues I could talk about. I'm not going to go back and retread the meeting contract stuff. I think I've talked enough about that for today's discussion. Privacy and data security issues are huge these days, as I know you and Tom and others in your firm know. And it's an area that we deal with all of the time. I said earlier that we kind of serve as outside general counsel to most of our clients and deal with a very broad array of legal issues. There are a handful of issues, though, that require really specialized expertise that we don't have. And in those probably 6-8 areas, we've developed kind of outsourced relationships with other firms, primarily other lawyers like me, former big firm lawyers who are now in small firms or their own shops, who have like a similar style of practice and very responsive and practical and all the rest. And this is one of those areas in the privacy and data security area where we have a terrific lawyer named Michelle Cohen and her colleague Nicole that we outsource this work to, and we are increasingly outsourcing things to them. Even just a contract that we're reviewing, but the contract is going to involve operations in the EU and whatnot. So we have GDPR issues and other things like that. It comes up all of the time, and so we'll ship the contract over to Michelle and Nicole, to work on those provisions or to deal with all sorts of stuff. When there's a data breach, but there's so many things that you can do in a contract, particularly when you're dealing with vendors, which is kind of your area of specialty, and you're outsourcing certain work as a nonprofit and association to a vendor, making sure you have all the necessary protections, reps and warranties on their part, other measures that they're going to undertake. What happens if there's a data breach? What are their obligations? It's so critical. There's so much you can do prophylactically in a contract to deal with privacy and data security issues. It's just an absolutely critical area of law.
Yeah, that's great. Well, last thing, Jeff, real quick, I'm just curious, as you look ahead, anything on the legal radar in regards to regulation or things that you're seeing in the industry and trends that you think are important for people to be looking at as they're putting their plans in place for the next 12 months?
I get that. I've gotten that question a lot over the last 25 years that I've been doing this. There's always new things developing, right? We were just talking about privacy. I would not be surprised to see, it's one of the few areas where there actually is a fair amount of agreement between a lot of Democrats and Republicans on Capitol Hill. I wouldn't be surprised to see some sort of a new federal privacy law, kind of akin to the California Consumer Privacy Act and GDPR, which are both kind of a similar construct. Would not be surprised to see something like that at the federal level. We're certainly seeing the federal regulators, take a much stronger interest in the enforcement of the antitrust laws, particularly when it comes to monopolies, but we may well see it in the areas that affect associations, which is kind of what we call horizontal kind of antitrust violations, actions amongst competitors, which associations are by definition. But the FTC and Department of Justice Antitrust Division in the past have been very active at times, along with state attorneys general, in looking at the competitive actions of associations and taking action where there's anti-competitive practices on the part of associations. The most recent U.S. Supreme Court decision from a few years ago involved the California Dental Association, a case brought by the FTC involving enforcement of their code of ethics against their members. And the Supreme Court upheld the FTC's position on that. So, we may well see more enforcement in that area. We might well see a federal privacy law. One area where we really haven't seen a lot of enforcement for years is from the IRS. There was a period of time when I've been practicing, probably a decade ago, when the IRS started to get really active on the examination front, doing audits of tax-exempt organizations. And I handled my colleagues and I, probably about 75 of them. We've seen very little action from the IRS, and I don't expect that to change anytime soon. But all of that being said, the issues that we counsel our clients on and that come up day to day, of course, a lot of it is driven by COVID these days. So many things. COVID has forced change. Change forces lawyers to get involved because this contracts is, trying to get out of contracts, renegotiate contracts, entering into new contracts, all of that sort of stuff. But the areas of law that we counsel on, the law really hasn't changed that much over the years, whether it's federal tax exemption. I mean, the antitrust laws pretty much haven't changed in over 100 years. Little interpretations from courts and whatnot, but the underlying laws haven't changed. Copyright laws largely unchanged, for decades. Same with trademark law. Same with employment law. Sometimes we see some changes in through court decisions and whatnot, and we see some changes at the state level to introduce more protected characteristics. But the core stuff doesn't really change. Contract law per se really hasn't changed. We had the kind of the onslaught of digital signatures a number of years ago, federal law there, but most of it hasn't really changed. And so while new developments always get the headlines, it's really the old stuff, the bread and butter stuff. Corporate governance,
blocking and tackling,
state nonprofit corporation statutes. They really don't. They rarely change. I mean, right now I'm part of the American Bar Association's Nonprofit Organizations Committee, and there's a subcommittee that works on the Model Nonprofit Corporation Act. They are working and close to releasing kind of the newest version of that, which will cause some change at the state level, but not a ton. So I guess what I'm saying is, don't always look for the headlines and what's new and different. It's the same old stuff that really drives most of the legal concerns, risks, that nonprofits have to deal with.
That's excellent. Well, Jeff, it's been so great to catch up with you. I really appreciate your time, your insights, and just wish you continued success and hope you have a great day.
Thanks, Paul. You too. Thanks for having me.
All righty. Take care. Bye.